seated. Now, this morning we are hearing from Mr. Barton, who will come in from a remote location. And I know we have a number of council who are also online. In view of the fact that we have a number of people on the eastern seaboard, I think it might be appropriate today if we were to change the sitting hours, and what I suggest is that we sit from 10 a.m. till 11:30 a.m., then take 30 minutes, and then sit from 12 till 1, and then see how we go from there, if that's convenient to everybody. Now, can we have Mr. Barton? Good morning, Mr. Barton. And I think Ms. Boros, you will be examining.
Yes, Commissioner.
Thank you. Mr. Barton, do you have do you wish to take an oath or affirm?
Oath, thank you, Commissioner.
Do you have the form of oath, or I can read it to you if you like?
Oh no, I do have it if that's convenient.
All right. Well, if you could then just tell us your full name for the purpose of the record.
Kenneth McRae Barton.
And if you would then read the oath.
Yes. I, Kenneth McRae Barton, swear by Almighty God that the evidence I shall give to this commission shall be the truth, the whole truth, and nothing but the truth.
Thank you very much, Mr. Barton. Ms. Boros.
May it please the Commission. Mr. Barton, you appear today as a witness in response to a summons dated 19 July 2021, is that correct?
Yes, that's correct.
Enclosed with that summons, there was a schedule with a list of topics that you were invited to address in a witness statement. Did you do that?
Yes, I did.
Do you have in front of you a copy of that witness statement?
Yes, I do.
And is it dated 3 August 2021?
Yes, that's right.
Is your statement true and correct to the best of your knowledge and belief?
Yes, it is.
Commissioners, the document number that's been given to the witness statement is WIP.0012.0001.0001.0001. I attend to that statement.
Thank you, Ms. Boros. The witness statement of Kenneth McRae Barton dated the 3rd of August 2021, bearing the identifier number that Ms. Boros has just read out, will be admitted into evidence as an exhibit.
Please, the Commission, that's Mr. Barton's evidence in chief.
Thank you, Ms. Boros. Mr. Futrell.
May it please the Commission. Mr. Barton, my name is Michael Futrell. I'm one of the counsel assisting the Commission, and I'm going to ask you some questions. I don't know if you can see the room. There's quite a few people in it, so I've identified myself so you know who I am. There's a few others.
Yes.
I may wish to ask you some questions after me. Could I start by just referring you to an early part of your statement where you've identified that you gave, I think, 7 statements, written statements in the Bergen inquiry last year?
Yes.
Have you had an opportunity to read over those before today and refresh your memory?
Yes, I have.
All right. So some of my questions, I noticed in answer to some of the topics you've made reference to those statements. So some of my questions will deal with the subject matter of those statements as well as the one that's just been tendered. Can I ask if you could turn to under the topic, the roles you held within the Crown Group, and I just have a couple of questions to ask you about these matters. You've indicated that you were the CEO of Crown's digital business from 2017 to 2021. Which businesses were involved in that description?
Yes, there were a number of businesses. The main part of that portfolio was the Betfair business, which was established in 2004. And it was originally a joint venture, but later in 2014 became wholly owned. by Crown Resorts. That was the main part of that portfolio. There was also a social gaming business called DGN, and some small digital assets as well.
And you were the CEO of those businesses?
Of that portfolio, yes.
And am I right in thinking that the Betfair was regulated out of the Northern Territory?
Originally Tasmania, but later Northern Territory, that's right.
And to your knowledge, were there any AML CTF programs involved with the digital business?
Yes, there were.
And do I understand then you as CEO of that part of the business, you were familiar with the AML CTF programs for those businesses?
Yes.
And you've indicated also that you became the CEO of Crown Resorts in January 2020. What was the process by which you were appointed as the CEO of Crown Resorts?
I was notified by Helen Coonan that the board had been considering a change in the leadership of Crown Resorts and asked me if I'd be willing to take over the role of CEO in January 2020.
Were there any discussions before your appointment with anyone other than Ms. Coonan?
No, not in relation to that new role.
Could I ask if I could ask you to turn now to some other parts of your statement to this commission? I've got some questions that relate to some of the answers you've given. If I could ask you to look at paragraph 12, and this is I'm now referring to the period during which you were the CFO of Crown Resorts, and there you've indicated that you had no authority or responsibility for the operational aspects of Crown, or responsibility for the casino compliance matters. And then could I ask you then to turn forward in your statement, or further into your statement, in paragraphs 55 and 56, where you've dealt with your understanding of your duties and responsibilities as a director of the various companies within the group. Now, with respect to Burswood Limited, what was your understanding of your role as a director of that company?
As a director of the company, to be familiar with all of the activities of the group, the Burswood Limited group, to bring that diligence to board meetings, and to be involved in assessing all of the material that was brought forward to that board.
And what about your role as a director of Burswood Nominees Limited?
Well, Burswood Nominees didn't meet regularly, and as a director of that company, also to look at matters that were brought to the attention of the board and assess those matters.
And Burswood Resort Management Limited, your role in... I beg your pardon?
No, sorry, I cut across you.
I was going to ask the same question about Burswood Resort Management Limited.
Yes, again, it met on not regular basis, but to consider matters that were relevant to Burswood Resorts Management.
And so, am I right in thinking that in the role as a director of Burswood Limited, it operated effectively to provide oversight of the two other subsidiaries, Burswood Nominees and Burswood Resort Management?
Yes, most of the material that related to the, if you like, Burswood Limited group was brought to the attention of the Burswood Limited board.
Now, do I understand by reference to your answer in paragraph 12, where you dealt with responsibility for the operational and compliance aspects. Are you drawing a distinction in your mind there between your role as a CFO of Crown Resorts and your role as a director of these companies, or do you see it as part of the same role?
In relation to question 12, that was in my role as CFO. So in my capacity as CFO, I had some executive responsibilities, and those were largely around the corporate function. So finance, treasury, federal taxes, investor relations, financial reporting, those aspects. So my capacity as CFO, those were my responsibilities, not responsibilities within the operational aspects of the casino business.
All right, but as a director of Burswood Limited and its subsidiaries, would you accept that you had a responsibility for oversight of operational and compliance matters for those companies?
To the extent there were matters that were brought to the board for the board's attention, yes.
Now, can I now refer you to paragraph 45 of your statement? And you've mentioned there the appointment of a Crown's Chief Risk Officer. When was that appointment made, to your knowledge?
I believe that was around late 2017.
And who held the position of the Chief Risk Officer?
From 2017.
Yes.
Anne Seegers.
And did she remain in that position for the time that you were employed in the Crown Group?
Probably just to clarify that answer, she became Chief Risk Officer as part of the restructuring I did in 2020. Her title from 2017 was not Chief Risk Officer. It was, I think, more General Manager Risk and Internal Audit.
I see. And in that function did she effectively hold the same responsibility, which is to say she had responsibility for the risk management of the Crown Group as a whole?
She had a role in the strategy, the risk management strategy for the group as a whole, but she reported through to another executive, Mr. Preston, who then reported through to Mr. Felsted. So she probably wasn't in a position to influence the risk function of the group, but was instrumental in developing the risk management strategy.
All right. That answer to the description just given, is that the position as it stood prior to 2020, is it, that she reported to Mr. Preston?
Yes, that's right.
And after the establishment of the position Chief Risk Officer, did she report then to Mr. Preston or to someone else?
No, she reported through to the Risk Management Committee and to the CEO of Crown Resorts.
And that Risk Management Committee you're referring to is the Crown Resorts Risk Management Committee, not a committee of any of the subsidiaries?
That's correct.
And in this, so I could break the periods up then. So for the period 2017 to 2020, was there a risk officer for Crown Perth?
I'm not sure if there was anybody that had the title of risk officer for Crown Perth, but from 2017, the risk management function was overseen by the group I mentioned before, Ms. Seegers, who reported to Mr. Preston.
I see. Now, can I ask you to refer now to another part of your statement? This is paragraph 50 to 53, which deals with some your induction and training over the course of your employment with the Crown Group. And you've mentioned in there, I think, some online AML training.
Yes.
Can I ask you, we just call up CRL.566.003.0001, please? I hope you can see. Can you see? Have you got a screen in front of you, Mr. Barton?
Yes, I can see that.
Is this the kind of online training that you recall receiving? Is this the one of the modules that you have a recollection of reviewing?
Yes, this appears to be the current version of the online training module, or the then current version when I was last there.
And in what way did you undertake the training online? Was there a requirement to do it every second year and record it in some fashion, was there?
It was online. For me, there wasn't a requirement to record the undertaking of that training every year, but I did it initially, and then when this was significantly revamped in 2020, did it again.
I see. So there wasn't anyone looking over your shoulder, as it were, to ensure you were doing it, but you were doing it as a matter of course in your role as CFO, were you?
Correct.
When was the last time you can recall refreshing yourself with the online training?
In 2020, when the new training module was introduced.
And was there a training module in place in 2014?
There was, I don't recall the content of it, but there was training that was done from induction when I joined.
All right. Now, as a director of, you were a director of Burswood Limited, and you were also a director of Crown Melbourne Limited, were you not?
Correct.
And did you understand that each of those, withdraw that. Did you understand that Burswood Nominees was the casino licensee in Western Australia?
Yes.
And did you understand that as the casino licensee, it had obligations under the AML CTF Act, that's the federal act, to have an AML CTF program?
Sorry, Mr. Future, under which obligations?
Did you understand that Burswood Nominees had an obligation under the AML CTF Act to have a AML CTF program?
Yes.
And were you aware that from time to time there were internal audits undertaken that included the Burswood Nominees AML CTF program?
Yes.
And you received those internal audit reports from time to time as a director of Burswood Limited?
We received a report as part of the board papers that summarised the internal audit work that was being carried out.
All right. Would it be fair to say that as a consequence, or I should say that you also received, as a director of Burswood Limited, from time to time, legal compliance and risk reports?
Yes.
And they, from time to time, also dealt with amendments and variations to the AML CTF program of Burswood Nominees?
Yes.
So in the course of the period from your commencement of your employment with the Crown Group until your departure earlier this year, you gained, I imagine, a general understanding and awareness of money laundering and terrorism financing.
Progressively, but not with direct exposure to the AML operations, if you like, or the AML activities.
Did you mean by that you didn't have an intricate knowledge of the finer points of detail of the program or the operating procedures, but you understood generally that casinos were exposed to the risk of money laundering?
I had some understanding of that, yes.
Were you also aware, or did you understand or gain that understanding that casino operations are vulnerable to criminal infiltration?
Yes.
And did you understand or gain an understanding that there are many ways in which criminals may attempt to use or influence, or gain influence to utilise the services provided by casinos for illegal purposes.
When you say gain understanding, I guess I'm just trying to make sure I answer your question properly.
Yes.
I didn't have a great deal of exposure to that, but did progressively gain understanding, particularly over the last year or two, about the prospect of criminal activity in the context of AML.
All right. Now, did you understand that one vulnerability of casinos to criminal infiltration or money laundering involves the use of the cage with cash transactions in the cage?
Yes.
And another way in which money laundering may take place is through the use of the casino's bank accounts.
Yes.
And did you understand that the typologies of money laundering were not limited to transactions involving cash or bank accounts? For instance, there's ways in which money laundering may take place on the casino floor through the way in which gaming is conducted.
Some understand. I'm not sure of exactly what you're referring to there, Mr. Field.
Are you familiar with the expression bill stuffing, for instance?
Oh, yes. Yes. Although that, I guess, involves cash.
Yes. Or, are you familiar with even money betting as a concept?
Yes.
So the point really is you had understanding that money laundering was not limited to transactions itself, but there are many ways in which a criminal might try and utilise the gaming services offered by a casino to launder money.
Yes.
Were you provided with any specific AML CTF training by anyone within the Crown Group?
Not specific training, no.
Did you have any, whether it's called training or not, any one-to-one sessions with any of the AML team, for instance?
Certainly through the course of last year, I spent quite a bit of time with the then head of the AML team and gained a deeper understanding through the course of last year about the AML program and the AML issues to do with Crown.
And are you referring there to Mr. Preston or Mr. Stokes?
Mr. Stokes.
All right. Now, prior to 2020 and that the period during which you were the CEO of Crown Resorts, did you have any more in-depth discussions or sessions with any person involved in the AML program for the Crown Group?
Not in-depth sessions, no.
Can I just check one thing? If I just ask you, while we're in this part of your statement, to look at paragraph 54. And there's a reference there to Crown Perth. And there are a lot of witnesses in this commission, Mr. Barton, and most people have refer to Crown Perth. And I just want to understand or ensure that my understanding of the way you use it is the same as everyone else's. By Crown Perth, you mean to refer to Burswood Limited and all of its subsidiaries? Yes,
that's right.
Now, I'll draw attention now to paragraphs 57 to 60 of your statement. And in paragraph 57, the last sentence in that paragraph, you have indicated that Burswood Limited was the body which set the overall strategic direction for Crown Perth, including in relation to the governance of Burswood nominees. Can I ask you what you mean by the overall strategic direction?
Yes. So within the Burswood Limited Group, the body that would receive information about the operations, strategic plans, budgets, and get the most detailed operational updates in relation to that Crown Perth Group was the Burswood Limited Board. It would receive also the reports from the legal risk and compliance teams and receive information about the overall direction of the group. So the body that within the Crown Perth Group, as I've defined it, that had the most involvement in setting the direction was Burswood Limited.
I just want to understand what you're meaning by strategic direction. So what I understand from that answer, largely the material you've referred to is of an operational kind, where operations have been carried out by the executives or the managers, and they're reporting to Burswood Limited on the way in which the Crown Perth business has been operated. Is that a fair assessment of what you've just said?
Well, I think I also said not just operational, but also the legal risk and compliance aspects and other matters that were brought to the attention of the Burswood Limited Board.
All right, but in terms of the legal risk and compliance matters, am I right in thinking that the framework, the risk management framework, was established by Crown Resorts Limited?
Well, when I joined the Burswood Limited Board, there was already an existing risk management framework in place. And that risk framework was basically managed within the Crown Perth Group.
All right, so we're talking then about in 2010, is that right?
Correct.
So at the time you joined the board of Burswood Limited, there was an existing framework.
Yes.
And did that change at any point in time, to your knowledge?
Well, the risk management framework was modified and enhanced over the 10 years I was there. There were additions made. There were different approaches to the identification and management of risk, although some of the fundamental principles stayed the same.
All right. So at the time you joined in 2010, was there a Crown Resorts Limited Risk Management Committee?
Yes.
And was there a Crown Resorts Group risk management framework or policy or something of that nature?
There was an approach to risk management that was consistent across the group. I don't recall if there was a Crown Resorts risk management strategy that encompassed all of the operations.
All right. Would it be fair to say that at some point in the time you were there, the direction or control of the overall risk framework became more centralised through the Crown Resorts Risk Management Committee?
I think the approach to risk management became more consistent across the group and was enhanced by the risk manager rather than the risk management committee.
Okay. Now, just coming back to some earlier questions, your answers respect of Burswood Limited's function or role in that. Was it, there was an existing framework and risk register for Crown Perth?
Yes.
And Burswood Limited, in your experience, was concerned with reporting against that existing risk management framework, the risk register and risks in it?
The board received reports about that risk register and that risk framework, yes.
Now, just to understand a bit more about what you mean by strategic direction, when the Crown Towers development was undertaken, which board within the Crown Group was the deciding board for the decision to undertake that development?
That decision ultimately was made by the Crown Resorts Limited Board.
And what role, if any, did Burswood Limited play in that decision-making process?
Well, the Burswood Limited Board was given presentations about the prospects for that development, but given the scale of that project, ultimately that was a decision that was taken to the Crown Resorts Board.
All right. Would you characterise that as a strategic decision?
Yes.
A fairly major strategic decision for the group as a whole?
Yes.
So would it be fair to say that the more significant strategic decisions, at least, were taken at the Crown Resorts Limited level rather than the Burswood Limited level, insofar as Crown Perth?
Sorry. Yes, a decision of that scale, what is ultimately a $650 million investment, was something that had significance to the group in terms of its the funding needs, the capital needs, and the scale of that investment. So that was something that was important for the Crown Resorts Group to take into consideration in its plan.
All right. Now, in your role as, I'm now talking about the period you were CFO predominantly, and as a director of I'll just call it Crown Perth, or your role in Crown Perth, did you develop or have an understanding of the international commission business, or VIP International, whatever the label you want to attach to it?
Yes, some understanding.
And did you understand that it was effectively a separate business unit in connection with that activity?
A separate business unit to perhaps some of the other operating businesses, but I guess from my perspective, the business units were typically Crown Melbourne and Crown Perth.
Was the international commission business run out of Crown Perth, for example, for those patrons who visited Crown Perth?
There was an international commission business function in Crown Perth that dealt with patrons who visited Crown Perth, although a lot of the functions of the VIP International business were managed out of Melbourne.
All right. So when it came to decisions regarding the extent to which there would be international commission business in Perth, to your knowledge and understanding, which entity within the Crown Group was making decisions about the extent to which Crown Perth would be involved in international business?
I'm not sure I could identify who in the Crown Group would have been making decisions about which part of the VIP business went to Perth or Melbourne.
Was there a decision-making process by which business was, if you like, identified for Crown Perth, to your knowledge?
But my understanding of the way the marketing team worked to try and promote the properties was they were looking to promote all of the properties. It was really a customer choice, by and large, which property they would visit.
All right. So in terms of strategy of the international business, was that something that was directed by the Crown Resorts Limited Board or the boards of the individual properties?
I think the VIP International strategy was developed by both properties. So if I think about the Crown Limited Board, it would receive a strategic plan for VIP International, which would have a component of the business in Crown Perth and a component of the business in Crown Melbourne. But the way the Crown Resorts Board received its information, it was a a combined result for both Melbourne and Perth, including international commission business.
All right. So were there targets set for the international business, financial targets identified for that business, to your knowledge?
Well, the budgets that were set were on a property basis. So there was a budget for Crown Perth, including the international, the VIP business, and a budget for Crown Melbourne, including the VIP business.
And which entity in the group approved those budgets?
Well, ultimately, it was the Crown Resorts Group that approved it, but there was also a process where those plans were presented to the Crown Melbourne and the Crown Perth boards.
All right. So you said Crown Group. Do you mean Crown Resorts Limited?
Crown Resorts, yes.
So insofar as the strategic direction of that business goes, that's to say the international commission business, would it be fair to say that the strategic decisions about that were made at the Crown Resorts level?
Well, I think it was both the Crown Resorts and the subsidiary boards, but predominantly it was Crown Resorts who looked at the overall plan and strategy.
All right. Now, there was a CEO of Crown Perth at one time at least, and he became the CEO of Australian Resorts. Correct?
That's correct.
Was there a CFO for Crown Perth as well? Am I right in thinking that?
Yes, that's correct.
And the person in that role, did that person report to you as a CFO of Crown Resorts?
No, the CFO for Crown Perth reported to the CEO of Crown Perth.
All right. And there was also a COO of Crown Perth, Chief Operating Officer?
There was. I'm not sure about which time period we're discussing now, but there was certainly for a period a COO of Crown Perth.
All right. And there was a person occupying a managed position of legal risk and compliance.
Yes.
With the group I've just described for Crown Perth, they would have made up the senior executive team in Perth?
There would be other senior executives, but those three would be an important part of that executive team.
Well, so we've got CEO, CFO, COO, and legal risk and compliance. There's 4. Yes. Any others that you can think of that would?
There would have been a head of HR.
Right.
And I think at various times the COO was responsible for gaming, and there were heads of hotels and food and beverage.
All right. Now, to your knowledge, which entity within the Crown Group made decisions about who would be employed in those roles?
It might be important to separate some of those roles.
Yep.
So in terms of the people who reported to the CEO of Crown Perth at the time, that would have been a decision made by the CEO of Crown Perth. He may well have sought endorsement for those decisions, but that would have been principally the decision maker for those. The CEO of Crown Perth, that decision would have been made by the CEO of Crown Resorts.
Right. Now, insofar as you mentioned the CEO of Crown Perth may have sought endorsement, is that something that you know from your own knowledge, or are you speculating?
No, that I don't know from my own knowledge.
Okay. Now, insofar as the appointment to the various boards of the subsidiaries of Burswood Limited itself and its subsidiaries, to your knowledge, which entity within the group made decisions about who those appointments would be?
Well, the appointments to the Burswood Limited board, there was, I think, only one during the time I was there. And that decision, I think, was put forward by the chairman of Burswood Limited.
So are we referring now to Ms Fuster's appointment?
Yes, that's the only one I can recall occurred during my time on the Burswood Limited board.
And the recommendation came from Mr Poynton. Is that what you mean by the chair?
I think at the time the chairman was Mr Alexander.
Right. And at that time, Mr Alexander also was the executive chair of Crown Resorts Limited, correct?
Yes, I think that's correct.
And what about the subsidiary boards, Burswood Nominees, of which you were a director, and Burswood Resort Management?
Yes, I'm trying to recall if there were any appointments to directors of those entities. I think there was, there might have been some appointments during my time, but I can't recall if there were any appointments to the boards of Burswood Nominees or Burswood Resorts Management during that time.
All right. Now, can I return to a topic we briefly dealt with earlier, which is the risk management framework? And you've dealt with this in your witness statement at paragraph 61 to 66, in part. Please refer to those. And also there's a mention in, I think, 103 to 105. Now you might recall that there was a question about risk tolerance and risk appetite, and some other questions about your understanding of the risk management framework for the various Crown Perth entities. I think in answer to some of my earlier questions, you were breaking up the risk management framework into different time periods, one of which coincided, I think, with the appointment of Ms Seegers in a role in Crown Resorts. In your statement, you have referred to some documents. I just want to ask you to, if I could call those up and ask you some questions about them. One CRW.703.001.1713. Which is a Burswood Limited agenda paper, and the page pinpoint is 1775. And you'll see there's a reference, there's a board limited, it's a paper by Ms Seegers to the Burswood Limited board, and a reference to the Crown Resorts Risk Management Committee meeting to consider enhanced articulation of the company's risk appetite. And it goes on to say that risk appetite is to apply to the Crown Perth and Crown Melbourne. I'll just show you some other documents, Mr Barton, before I ask you a question about this. Then you've also referred, I think, right in saying, to the minutes of the meeting, which are CRL.627.001.0529. And the pinpoint is 0534. There's a reference to risk appetite and Ms Seegers attending the meeting and the paper being taken as read. A little earlier, when we were dealing with the the way in which risk was dealt with by Burswood Limited, I understood your evidence to be to the effect that the appetite for risk or the risk tolerance was, maybe putting words in your mouth to some extent, but the risk process was managed by Burswood Limited. Was there a change in 2008 whereby the risk appetite was set by Crown Resorts and essentially the framework was then imposed, might be too strong a word, but the overall framework was put on to the properties in Melbourne and Perth, and they were expected then to implement it?
In the year 2018.
Yes.
And I think this was an improvement in the risk management process that was driven by Ms. Seegers and the risk management function, and bringing the concept of a risk appetite to the processes at all of the properties and the businesses. And I think the concept of a risk appetite and embedding that in the risk management process was a centralised decision around process, but the boards of the subsidiaries were asked to consider the risk appetite, and given the risk management function was largely driven from the business level through the boards, it was important that those boards understood what would be escalated to them through the risk management process.
And what, if a matter was escalated to the, say for example, the board of Burswood Limited of a risk nature, in your experience and to your knowledge, was it then escalated, to use that expression, from Burswood Limited to Crown Resorts if required, or was the reporting function taking place to Crown Resorts through the Risk Management Committee itself?
The Risk Management Committee at Crown Resorts would receive the report against the material risks, and the escalation process was to both the Risk Management Committee, potentially the entire Crown Resorts board, as well as to the Burswood Limited board.
So just so I understand the way this reporting works, is it the case that, and you're aware there was an ERCC, or the Executive Risk Compliance Committee in Perth?
Yes.
It reported to the Burswood Limited board when it
Yes.
and it also reported to the Crown Resorts Limited Risk Management Committee.
I think the process probably was that the Crown Perth group or the Burswood Limited group would report to the Risk Management Committee. So the ERCC would report to the Burswood Limited board, but the Crown Perth group would prepare their risk assessment and their risk maps and present that to the Risk Management Committee.
All right. But if there was a need to escalate any risk management issue, it ultimately would be escalated to the Burswood Limited board and via the Crown Resorts Risk Management Committee, the Crown Resorts board. Is that right?
Yes, that's correct.
So in a sense, there were two masters for the risk management of Crown Perth.
Well, I guess there was two recipients of the risk report.
Right. Can I ask you now to refer to some other parts of your statement, paragraph 70 through to 77, and you might recall there were some questions asked about the way in which, or the extent to which there was influence over the decisions of the Crown Perth companies, and 82 to 84 as well. And we've got some questions around management structure. Now, can I start by the position as it stood when you were the CEO of Crown Resorts? And at that time, is it the case that the CEO of Australian Resorts, Mr. Felstead, reported to you?
Yes, at the beginning of last year, that's true, through till essentially the end of last year.
Yes, and obviously he had the general over management of Crown Perth, but did he from time to time seek your instruction and direction on matters relating to the operations of Crown Perth?
Yes.
And did you understand it to be your position or authority to essentially give him instructional direction that he would be required to follow if you had divergent views?
Yes.
And to your knowledge, was that the position as it stood prior to your appointment as a CEO? In other words, when Mr. Alexander was the executive chair?
That would be my assessment. That would have been the case as well.
And prior to that, Mr. Craigie occupied the position as well?
Yes.
And so in your experience as a director of Burswood Limited, were there occasions when the CEO of Crown Perth, whether it be when Mr. Felstead was just the CEO of Crown Perth or when he was CEO of Australian Resorts, sought and obtained instructional direction from the Burswood Limited board itself?
Well, there would have been decisions that were put to the Burswood Limited board, things like approval of budgets and decisions around strategic matters. They would have been put to the Burswood Limited board.
All right. So the Burswood Limited board met about 4 times a year. It kept minutes of its meetings, correct?
Yes.
And those minutes were generally approved at the next meeting after the preceding meeting?
Yes.
And to the extent any resolutions were made, they were recorded in the minutes, is that right?
Yes.
So if we're to find any decisions of any nature that have been made by Burswood Limited, we would find those minuted and recorded in resolutions of the board.
Yes.
So if and to the extent any direction or instruction was given to Mr. Felstead by the Burswood Limited board, we would find that in a record in the minutes, is that right?
And any major decisions, yes.
So can I just, again, I want to return to the period when you were the CFO of Crown Resorts, so prior to January last year. What if any, oversight did you have in that role of the financial affairs of Crown Perth?
Perhaps when you say the financial affairs of Crown Perth.
Well, did you play a role at all in the budgeting process for Crown Perth?
Well, the budget was prepared by the finance team at Crown Perth and presented to me and others for review.
For your review as the CFO of Crown Resorts?
As the CFO of Crown Resorts.
And was that budget approved then by the Crown Resorts board, was it?
Ultimately, it would have been combined with the other budgets and put to the Crown Resorts board, yes.
And what about there was a should I withdraw that? in this, the Crown Resorts level, was there a finance team under your supervision?
Yes, a small finance team, and its responsibilities were largely around external reporting. So the consolidation of the operating results, the preparation of external reporting, dealing with the external auditors, and looking at, if you like, corporate level finance matters. So matters that relate to the group as a whole as opposed to the operating businesses.
Okay, now, where in that structure did Mr. Costin sit?
He was in the treasury function in the corporate office.
And was Treasury part of the finance team under your supervision?
Yes,
So Treasury was dealing with the major financial affairs of the group as a whole. Is that correct?
yes, funding, access to capital markets, treasury risk management, interest rate, foreign currency risk management, all those operational treasury matters.
All right. Now, with respect to the financial reporting of Crown Perth, it reported as one single consolidated business unit to the you as CFO.
That's right.
And so there wasn't any breakup in its financial reporting of the various revenue streams for each of the individual corporate entities.
Not the corporate entities, no.
So you understood, I take it, that Crown Resorts Management was the employer of the majority of the people performing services at Crown Perth?
Burswood Resort Management?
Sorry, Burswood Resort Management.
That's my understanding.
Was there, to your understanding, any mechanism by which it was remunerated within the group for the services it provided to Burswood nominees?
I don't have any understanding of that.
So what I'm asking you is, was there some intercompany recognition of debt and credit that dealt with the provision of those services, or did it just simply operate at a group level?
I don't know what happened, if you like, in the individual company ledgers. What we saw was a consolidated set of results that would have picked up the results from all of the subsidiaries.
So any if I could put it this way, any of the intricacies of the Perth Casino intergroup credits, debits, liabilities, assets, was that dealt with by the finance team in Perth, was it?
Yes, that's right.
So your visibility on that, was it limited to receiving a consolidated set of accounts?
That's right.
Can I ask you now to turn to paragraphs 107 to 126 of your statement, and these are in response to a series of questions that were asked about the International Commission business. Actually, just perhaps before I move to that topic, can I just ask you one more question about the way in which the finances were operated from Crown Perth? Was there a person or a division responsible for the transfer of funds between bank accounts within the group? Well, I mean, for example, you have an operating account for Crown Perth, funds are being received into that account, wages are being paid, all of those things are being dealt with, and then there will be a surplus. Was there a process by which you swept up and picked up the surplus and transferred it to another company within the group?
There would have been a process to move surplus funds into a central account, yes.
And was that the operation of that process, was that within your remit or the individual properties?
That I'm not completely sure, but that's most likely a central treasury function.
And in that process, was there reconciliations done between bank accounts?
Well, the reconciliations of the bank accounts would have been done at the property level within the finance team, but the movement of funds would be managed at a treasury level. Just give us a sense of how that worked in a practical way. Was there a preset or predetermined process, or was it someone who had their eye on the account, it looked like there was a surplus, time to move it to a central account? I think it was, I'm not 100% sure, but I think it's more likely the latter, that someone would have been looking at, or the treasury function would have been looking at the overall balances across the group and where it became efficient to move funds to between accounts.
And so if for instance, there was a movement of a sum of money from Crown Perth into a centralised account, was it part of your group's responsibility to record the intercompany positions at that point in time?
That would have been a combination of the finance team in Perth and someone in the treasury function.
All right. So although the group reported in a consolidated way to the ASX, there would have been accounts, management accounts within the group recording the transfer of funds from, say, for example, Burswood nominees to whatever the entity was in a central Crown company. Yes. All right. Sorry, can I just return to your statement, and I want to ask you some questions about paragraph 112 in particular. Now, the first question I have for you is, I understand from that paragraph there was a process of providing credit to junket operators.
Yes.
And I understand from that there was a credit team whose function was to assess the creditworthiness of the junket operator before credit was extended to them?
Yes.
And where was the person responsible for that located within the Crown Resort structure?
There was a credit team within the VIP group.
And so is that outside of the finance portfolio for Crown Resorts, your portfolio?
Yes.
Did you have an understanding of the credit function within that VIP team?
Not a deep understanding, no.
And so who in the credit area of the VIP business, who had the ultimate responsibility for the extension of credit?
Again, it's different time periods. For the period from around 2013, when Mr. Felsted had oversight of all of Australian resorts, he would have had the authority to determine the level of credit to provide to junkets.
And who was the person immediately beneath him in that structure for credit assessment?
Well, I think in the period from 2013 to 2016, that would have been Mr. O'Connor.
And was there anyone, is Mr. O'Connor, are his skills in the financial and accounting world, or is he more a marketing person?
No, he came from a finance background.
All right. So do I understand then from what you just said that the decision about which junket operators would be extended credit and the terms or extent of the credit were made within the VIP business itself?
Yes.
From a corporate risk profile perspective, was there no interest from the Crown Resorts finance area to ensure that credit was extended within appropriate boundaries or limits?
No, from a finance perspective, that authority was really within the operations team.
And did that extend also to recovery of any bad debts in that or recovery of loans in that area?
And they had responsibility for the recovery of loans as well.
All right. Now, I appreciate this maybe testing the limits of your knowledge, Mr. Barton, but I have some questions about the process of provision of credit to junket operators I would like to ask you. The first is, do you have an understanding of the way in which the junkets operated when they were being undertaken in terms of front money, credit and matters of that nature?
Some understanding, but not a deep understanding.
All right. Is it your understanding that typically, or in the ordinary course, credit would be extended to a junket operator for each junket undertaken at one of the Crown properties?
My understanding is that is the case, that for each junket visit there would have been a credit assessment done and an assessment of what level of credit to provide for each trip.
And is it your understanding that effectively credit was provided for each trip? So in other words, the junket operator arrived and in effect the relevant Crown property provided the front money for the junket by way of a loan?
Yes, except that to the extent that there were multiple visits and amounts outstanding, consideration would have been given to the overall amount that was owed by the junket. Okay,
just sticking with the typical cases, is it also the case that the settling of, let's say, the facility, let's call it that, for each junket, took place at the conclusion of the junket, at the time that the junket was over, and whether Crown was in front or the junket group was in front for the settling of the accounts at that point?
When you say settlement, I think there would have been, if you like, an accounting for that particular visit and an overall, if you like, settlement sheet done to determine the amount that was either owed or owing, but the financial settlement may have occurred sometime later.
Right. So now, to your knowledge, the collection, there's a number of people involved in a junket. The collection of the funds provided by each individual player was not something that was dealt with by either Crown Melbourne or Crown Perth, was it?
Not to my knowledge, no.
So the junket operator had, if you like, the commercial responsibility for collecting the money from the players involved in the junket.
My understanding of the contractual framework was that the contract was between Crown and the junket, not Crown and the individual players. Yes, and this is an advantage to Crown in the sense that it's dealing with one debtor, not many in a junket operation. Yes. To your knowledge or to your understanding, the process by which the junket operators obtained funds from the players
Did that include collecting cash from them?
I don't know the details of those arrangements.
Do you know if, to your knowledge, understanding whether a junket operator could in effect operate their own cage or their own facility for collection of cash and distribution of cash to the junket players?
I wouldn't have any knowledge of that level of detail.
All right. Can I ask you some questions about, just in a general sense, about another topic you touched on, which is in paragraphs 197 and 198. This is dealing with the response.
Mr. Field, just that last, I think, just to clarify that last answer, the thing I did have some knowledge of was, I think, what was known as the Sun City Cash Desk, which became a topic of the, I think, particularly the Bergen inquiry. So I did have some understanding that there was a Sun City Cash Desk, but that's the only understanding I have of the process of junkets operating their own, if you like, form of cage.
Yes. In the case of Sun City, that was a Melbourne casino matter, wasn't it?
Yes.
And Sun City operated its own, if you like, its own room when a junket was taking place at Melbourne.
Yes, that's right.
And so they operated their own separate cage service in Melbourne.
I understand it was described as a cash desk, yes, for a period.
But it was like cash desk. They received cash from their players and distributed cash to their players through that desk system.
I'm not overly familiar with the detail, but I think that's correct.
And that was closed. That facility was closed at some point in time.
Yes, that's right.
No, so the point I was really getting at, and whether you know this or not, I don't know, Mr. Barton, but whether they had a desk, a specific location within the casino or not, that process of collection of cash and distribution of cash to junket players could take place in a hotel room or outside the casino itself.
I don't know how that process works.
Thank you anyway for that clarification, Mr. Barton. So could I ask you now just to turn to your paragraphs 197, 198, and you asked some questions about responsible service of gaming or gambling. Now, I just want to understand what time frame are we really dealing with in this period, in what you described here as the responsibility of the Board of Crown Resorts, and to a great extent the Crown Resorts Responsible Gaming Committee oversaw the development and implementation of responsible gambling policies and procedures.
Well, I wasn't a member of the Responsible Gaming Committee, and I only really attended meetings of that committee from around 2018 onwards. So in terms of time period, this is probably more particularly from 2018 and onwards.
What I'm interested in is understanding the way in which the framework is developed and then implemented within the Crown Group. So do I understand from what you have said here that the Crown Resorts Limited Board oversaw the development of the responsible service of gambling framework through the committee?
Yes, that's right. I was going to say, so the Crown Resorts Responsible Gaming Committee was largely the body that oversaw and directed the strategic aspects of responsible gaming, and that was a committee of the Crown Resorts Board.
So this in terms of the strategy that was set for responsible service of gaming, that was set by the Crown Resorts Limited Board.
Yes.
And so you've indicated in paragraph 198 that you don't recall Burswood Limited overseeing the development of those policies or procedures.
That's right.
So would this be an example of a strategy or policy that's set really by the Crown Resorts for the group as a whole, and the properties are intended to implement them?
Yes.
So is it fair to say that the risk management framework, the responsible service of gambling framework, and the AML CTF program are all matters that were ultimately strategically set at the Crown Resorts level?
Different time periods, Mr. Future, but certainly by 2018 in relation to responsible gaming, from my experience, and in relation to risk management, and those two certainly from a Crown Resorts level. AML, I think, is a little different.
Well, I think you've given some evidence about the AML. I put that in there in the assumption you'd recall that evidence. So what I was referring to there is your evidence about a joint program being developed during 2019 and 2020.
Yes.
And so the joint program was one that straddled at least Perth and Melbourne, probably would have included Sydney.
Yes.
And that, it's fair to say, was also developed at the Crown Resorts level, was it not?
I think, practically speaking, it was developed by a team within the Australian Resorts team.
Right. The operational team for the
Yes.
two then operating casino properties.
Yes, that's right.
But it was intended to be a group-wide program, was it not?
That's right, yes.
And that was a matter that was taken to the Crown Resorts Board?
Yes.
And endorsed by the Crown Resorts Board?
Yes, that's right.
All right. Commissioners, I'm about to move to a different topic. I know it's a little early. I can start on it, or we could break now and come back 10 minutes earlier than you'd planned.
All right, well, Mr. Barton, is it convenient to you if we break now and take half an hour and come back at, it'll be about 11:45 our time, so 1:45 your time. Is that convenient to you?
I'm in your hands, Commissioner. Either way is fine.
All right, we'll come back at, well, hang on. No, it's 10 minutes to, we'll come back at 10 minutes to 2 your time.
Thank you, Commissioner.
So we adjourn to 10 minutes to 12. Thank you.
All rise. rise.
Please be seated. You can have the screen on. Thank you, Mr. Barton. Mr. Futrell.
May it please the Commission. Mr. Barton, I'd like to ask you some questions about the time you were on the director of Burswood Limited. At that time, I take it you received board papers before each meeting,
Yes.
and was it your practice to read those before the meetings took place?
Yes.
And approximately how long would it take you to, I know that the papers were of varying sizes, but what sort of preparation time did you spend before each meeting?
It would be some hours, particularly if we were travelling to Perth.
And in general terms, in the course of the meetings, I appreciate there was, for the majority of the time, there was Mr. Poynton and Mr. Roberts, and effectively two other executives of the Crown Group on the boards. To what extent was there discussion around, either from yourself asking questions or the independent directors asking questions of the CEO during meetings?
Probably the executives had some familiarity with the material from other opportunities. So I think the questioning was probably, if there was, would have been more for clarification from the external directors.
And what about you? Because you sat in a slightly different position to Mr. Felsteed and the other director, whose name now escapes me, but in that you were the CFO of Crown Resorts, you were not involved in the operations as such of Crown Perth.
So for up until 2017, the other director of Burswood Limited was Rowan Craigie.
Yes.
Who was the CEO of Crown Resorts.
All right. So in terms of Mr. Craigie and you were not as intimately involved in the operations of Crown Perth. Were you using the Burswood Limited meetings as a means of obtaining information? Or did you obtain it in other ways?
That was part of the benefit of being in the meetings, yes.
And so from your own perspective, were you using it as an opportunity to interrogate the executives of Crown Perth about the operations of Crown Perth?
Where it was relevant to my role as CFO, yes.
Could I ask, you might recall earlier I asked you some questions about the extent to which AML CTF matters came before the Burswood Limited board. I just want to show you a board pack from 2014, CRW.702.001.1721. Which is an agenda from a meeting in February 2014. And I take it this is something you would have read before you attended the meeting in 2014?
Yes.
And could I ask if we could please go to the pinpoint, which is at starts at page 1839, please, operator. Have you got that in front of you, Mr. Barton?
Yes, I do.
So it's a memo effectively from Mr. Preston to Mr. Felsteed about an update to the AML CTF program in 2014, and it's attached to it is a AML CTF program. Do you recall, or are you familiar with that document?
I'm familiar with it. I'm not sure I recall reading it at the time.
All right, but at the time, do you recall gaining a general familiarity with the nature of the AML CTF program?
Some familiarity, yes.
So, for instance, if I could just draw attention to some aspects of it, that Clause 6, for instance, makes reference to a risk awareness training program. That's on page 1847, operator. I want to draw attention to some other aspects of it before I ask you a question. Could we scroll to 1849, which is clause 12, which deals with transaction monitoring? And you'll see there's identification of monitoring of effectively transactions that are equal to or greater than the thresholds for the AML purposes, and a little further on there's reference to suspicious matter reports towards the end at the bottom of the page. Clause 13, addressing on the following page, addressing risk rating. Know your customer information. On the next page, enhanced customer due diligence. Clause 15. Clause 16, exclusion of high-risk customers. And clause 17, reporting obligations. Do I take it that you were at least familiar in 2014 and throughout the period that you were director of Burswood Limited with the existence of the AML CTF program, and that it dealt with the topics that, at least these topics that I've just taken you through?
Yes.
Can I ask you a question regarding clause 16 in particular, which is a risk-based issue in terms of the risk appetite of Crown Resorts Limited and or Burswood Limited itself in particular. And can I draw your attention that it reads, the AML CTF compliance officer should consider whether a high-risk customer who is known to have engaged in money laundering or terrorism financing. So I've just missed. Or is currently an extreme MLTF risk should cease to be a customer and be the subject of an exclusion order issued under the casino law or notice revoking the licence. The question really is, a person of that character, should they not simply be excluded rather than whether the compliance officer should consider whether to exclude them?
Yes, if somebody was found to have been one of those types of customers, yes.
So what did you consider this at the time, and whether there should be any discretion for the compliance officer to continue to to provide services to such a customer? There's to say a customer who is known to have engaged in money laundering or is an extreme risk.
No.
And given that, was there any discussion to your recollection of provisions of this nature in the AML CTF program during the period that you were director of Burswood Limited?
Well, that's quite a period. Obviously, the joint program was replacing this program in 2019, which revisited some of these provisions.
What I mean to say is, do you have any recollection of having considered yourself, in the period you were director of Burswood Limited, the extent to which a person known to have engaged in money laundering or to be an extreme risk should be a person with whom Perth the Perth casino should be doing business?
No.
Do, do you, with the benefit of hindsight, do you think that a provision like that really sums up the Crown Perth Casino's attitude towards AML-CT risk in a nutshell, in the sense that even in the face of the existence of an extreme risk of money laundering, there remained a discretion on the part of the compliance officer as to whether or not to continue doing business with such a person? In other words, the risk appetite set fairly extremely to one end rather than the other, isn't it not?
Yes, I think high-risk customer who's actively and known to have engaged in those things, there shouldn't be a discretion.
And really, it's indicating there's a willingness on the part of the casino operator, notwithstanding that risk, that patent risk, to continue to carry out and offer services to them, presumably for the reasons of financial gain.
Well, that's a discretion. What actually happened in practice might be different, but I agree that that discretion leaves that opportunity open.
And it leaves it open to the AML-CTF compliance officer in this program at that time.
Yes.
Not to the CEO of Australian Resorts, not to the CEO of Crown Resorts, and not to the board of Burswood Limited.
Yes.
Now, I take it, at least now you're familiar with the name Riverbank Investments Pty, is you there?
Yes.
And you were a director of that company for a period of time as one of Burswood Limited's subsidiaries.
Yes.
And you know that it operated some bank accounts.
Yes.
And it received funds from patrons who wished to gamble at the Perth casino.
Yes.
Now, to the best of your knowledge, were the accounts of Riverbank Investments operated primarily for the purpose of receiving funds from overseas patrons?
I don't know whether it was overseas. It was certainly receiving funds from patrons. I don't know if it was predominantly overseas.
And is it your understanding that the use of the name Riverbank Investments was adopted as a means of masking the destination of the funds? In other words, the funds were not masking that the purpose for which the funds were deposited was to be used for gambling at the casino.
Well, the account was in existence when I joined the company, but I did have some understanding that from the operating business's perspective, there was a desire by some patrons to not have the name of a casino in as the counterparty to some financial transactions.
Yes, and the reason for that was because the patron did not want to, or wanted to have the ability to disguise that they were using the funds for gambling at the casino.
To not have it obvious that they were remitting funds to a casino, yes.
And you understand that was one of the reasons for the operation of the Riverbank Investments account?
One of the reasons it was set up that way, yes.
Now, when did you gain that understanding? At what point?
I'm not sure of the specific time. I know that when the accounts were, when ANZ closed the account, it was indicated to me by the operations that they thought those accounts were valuable to have open, and that patrons were used to dealing with the name of that account, and there was a desire by patrons to continue to deal with the entity with that name.
So do I understand then from that answer that you became aware of this purpose in around the time of the closure of the accounts by ANZ in 2014?
Yes.
And to your recollection, who within the Crown Group was the person who made you aware of that purpose for the accounts, or the desirability of patrons to use the accounts in that way?
I don't recall specifically who that was.
Did you make some inquiries at the time?
I don't recall if I made inquiries. I think these may have been discussions that took place with people in the Treasury team who relayed them to me.
And by that, do you mean Mr. Costin?
Yes.
And are you suggesting that Mr. Costin had knowledge himself of this, or he acquired the information from someone else?
This would have been from discussions with the VIP team about the desirability of having these types of accounts.
And who in the VIP team, to your knowledge, was promoting the desirability of these accounts?
Well, there was a commercial function within the VIP team, and at the time it was Mr. Tyler.
Anyone else within that team that you can recall who had a desire to maintain accounts of this nature?
Not that I can recall.
Did you understand it to be an important part of the VIP business that they have available accounts of this character?
It was important that we had the ability to receive funds, particularly from overseas patrons, in advance of gaming.
And did you understand it to be some impediment to some players gambling at one of the locations in Australia if there were not such an account available to them?
Well, I think it was important for people who were travelling from overseas to make sure that when they came to the casino, they had access to funds to be able to gamble.
Yes, but they could have placed those funds into an account in the name of Burswood nominees, for example.
Yes, they could have.
So there wasn't any requirement to have an account operating in the name Riverbank Investments in order to receive patron funds, was there?
No, there wasn't.
So did you understand it to be the case that Crown Perth would lose business from patrons if it did not operate the Riverbank Investments account in this way?
I don't know if that position was ever put to me that patrons wouldn't come to Australia or to Crown if that account didn't exist.
So what then was the reason for maintaining the account after its closure in 2014?
Only a preference from the VIP team to have an account in that name for patrons to continue to access.
And to your knowledge, who was the person within the Crown Group who gave effect to the desire to open a new account for Riverbank Investments in 2014?
Well, account opening and closing was a function of the Treasury team.
Does that apply across the board? As in, all bank accounts were operated through the Treasury?
Opening and closing of accounts would have been coordinated through Treasury.
And Treasury was under your supervision, is that right?
Yes, that's right.
And does that mean to say that you ultimately knew and had authority and were the person who had the authority to open the CBA accounts in 2014?
Ultimately, yes, I had authority to do.
And did you authorise the opening of the CBA accounts in 2014?
I was aware they were being opened, but I didn't need to provide any authorisation. I think that was being able to be done within the delegations in the Treasury Department.
And was the person primarily responsible for that Mr. Costin?
Yes.
Was there anyone else, to your knowledge, involved in the opening of the CAB accounts in 2014?
the CBA accounts. The VIP operations team would have been aware of that because they would have needed to have worked with the customers to give them the details of the new banking arrangements.
And who are they? Who are they?
Again, that would have been coordinated through Mr. Tyler.
Mr. Tyler. What about the people on the ground in Perth and Melbourne dealing with the customers?
Yeah, so I think the finance teams in both locations would have needed to be aware of the new accounts being established, given they had oversight of that. Plus, the cage would have needed to be aware of that as well.
And by the cage, do you mean the general managers of cage in Perth and Melbourne?
Yes.
And was that Mr. Brown for Perth?
Yes.
And Mr. Howell, is it, for Melbourne?
No, I think at the time it might have been Mr. Hancock.
Right, Mr. Hancock. Now, did you understand when you became aware of the purpose for the operation of these accounts that it was, whether it was understood to be a Crown Group specific phenomenon or something that was undertaken more widely in the casino industry?
I may have had some understanding that it was a practice that existed in other places, but I don't recall specifically.
Upon becoming aware of the purpose for which the account was operated, did it raise in your mind any red flags, to use that expression, or alarm bells that an account of this character may facilitate money laundering?
Not at the time.
All right. Are you aware and do you understand the existence of informal or underground banking systems?
Not in any detail, no.
Are you aware of the existence of people who are referred to as money changers or money remitters?
I have some knowledge of that, but not in detail.
All right. And what is your knowledge of the operations of a money changer or a money remitter, whichever way you want to describe them?
Yes, my understanding extends to some knowledge that in some overseas jurisdictions there are organisations that will accept funds in a local currency and transmit those to a recipient in another jurisdiction.
And when did you gain that understanding of a money changer or a money remitter?
Probably only over the last couple of years as I've become more familiar with the AML programs.
Did you understand in 2014, around the time of the closure of the ANZ account, that there was an association between the operation of that account and money changers?
Not in the way I understand money changes now.
All right. So did you make any inquiries at that time around what the meaning of what a money changer was?
No.
And did you understand there to be some form of relationship between either Crown Perth or Crown Melbourne and money changers, either locally or overseas?
In 2014?
Yes.
No.
At all?
No, not in the way I understand money changes now.
No, what I mean to say, did you understand there to be a relationship between either Crown Perth or Crown Melbourne operationally and money changers either located overseas or in Australia for the purpose of patron funds?
Not in 2014.
At any time?
I've become aware of money changers who Crown has dealt with over the last couple of years.
All right. So you are aware then that Crown had some form of relationship with some money changers?
Yes.
Okay. And you became aware of that in the last
2 to 3 years.
2 or 3 years? When did Crown have the relationship with the money changers?
I don't know the commencement of that relationship.
Do you know if it...
Excuse me, I wonder if we could be a bit more specific about what the relationship is. It seems like this witness is being asked to comment on something without really knowing what exactly it is.
Just clarify that, please, Mr. Future.
What I mean is, did to your knowledge, did Crown Perth understand that a money changer would be used to remit funds for use in gaming at Crown Perth?
In what time period, Mr. Fusion?
At any time?
Not specifically in relation to Crown Perth.
All right, Crown Perth or Crown Melbourne then?
Yes, yes.
And was this in connection with the VIP business?
Yes.
And it was at your understanding that the relationship concerned knowledge of who the money changers were and that those people would be remitting funds for patrons to Crown Melbourne or Crown Perth?
Yes.
And did you understand the money changers to be overseas or in Australia or both?
The ones I was aware of were overseas.
And do you know the names of the money changer money remitters overseas?
Not the specific name. I know of one name that was used, but I'm not sure if that's their formal name or if it was the name that the business referred to it.
What was the name the business used to refer to them?
Described as Nenny.
Nenny. How would you spell that, Mr. Barton?
I believe that was N-E-N-E.
All right. And where overseas was Nenny located?
I don't recall specifically where they were located.
Any others whose names you can recall?
No, that's the only one that was raised with me.
And was there only one raised with you? Did you understand to be more than one?
I don't know.
Did you have any understanding of any other arrangements that either Crown Perth or Crown Melbourne had for receiving funds used for gaming in Perth or a settlement of gaming debts in Perth or in Melbourne where the funds were received overseas?
No.
What was your understanding of the way in which the money changer Nenny operated?
Only that they would be able to accept funds in their jurisdiction and then transfer those funds to Crown.
And, right. Can I ask you to just turn to your statement at 154. We've been covering a bit of this territory already, Mr. Barton, and you've made reference to your Bergen inquiry third statement at paragraph 41. I wonder if we could have that document. That's to say Mr. Barton's third statement in Bergen brought up as well, which is CRL 697. Point 001, point 0033 at page 40. I think we've been dealing with the topic in 41 and 154 to some extent already, Mr. Barton. I want to understand a bit more about what you mean in paragraph 154, where you have, in the last sentence, take into account you've prefaced it with your reference to paragraph 41. I just want you to explain to the Commission, if you don't mind. In the last sentence, 154, you have said these accounts were maintained by the finance team at Crown Perth and overseen by the VIP International business, with AML controls implemented by the AML team in Perth under Mr. Preston. So there appear to be three areas that are dealing with these accounts, as I understand that sentence. Could we start with what you mean by they were maintained by the finance team at Crown Perth?
Yes.
What do you mean by that?
So bank statements and entering the details of banking arrangements, doing bank reconciliations, and managing, if you like, the financial aspects of the bank account would have been managed by the finance team in Crown Perth.
Now, in the course of a reconciliation, is it the case that they would be provided with either the original bank statements or records of the bank statements in order to undertake a reconciliation between, I take it, the deposits, let's stick with Riverbank here for instance, deposits into Riverbank investments accounts and the correlation whereby they were allocated to a patron in an internal Crown Perth patron account?
Yes, they would need the bank statements to do that work.
So I may have been operating on an assumed state of affairs, so let's just make sure I understand this correctly. There was a process by which Crown Perth opened a patron, what they refer to as a patron account, correct?
Sorry, I'm going to say they opened a patron account.
Their own, yeah, in what the system called Psycho.
Right.
There was a patron account where a patron would have the facility to open an account with Crown Perth.
There would be a customer created within Psycho.
Right. Now, I'll put some propositions to you. You can tell me if I'm wrong or agree with me, or if you don't know, you can say so. Is it the case that funds received from patrons, whether it be into the Riverbank account or some other account, were allocated to a particular patron who had a patron ID and a patron account in Psycho?
Yes, I understand that's the case.
And in effect, wherever the money was sitting in the accounts of Crown Perth, whether it be in Riverbank Investments or in a Burswood Nominees account or some other account, they were treated in an omnibus fashion where the funds were obviously in the bank account of the relevant Crown entity, but were recorded as belonging in Psycho to the relevant patron.
Yes, that's correct.
Somewhat like a trust account, but without being held on trust.
I'm not sure about that, but certainly from a record keeping perspective, Psycho would record that the funds had been received on account of that patron.
So in the process of reconciliation then, is it the case that one of the aspects that the finance team in Perth was interested in was to ensure that funds received from a patron were correctly allocated to the patron's Psycho patron account?
No, that was probably being done more by either the part of the VIP international team, particularly for overseas patrons, and also the cage would have had a role in that as well.
So in what respect was the finance team undertaking reconciliations then? Is it just at the month end?
I'm not sure how regularly they did, but the responsibility for making sure that all the receipts and payments out of that account were properly recorded in the accounting system would have been the finance department.
Okay, and did that extend to ensuring that, for example, someone deposited $50,000 into Riverbank Investments account, the $50,000 was recorded in Psycho, in that patron's Psycho account?
No, that would have been more the responsibility of either the VIP team or the coach. So
what part of the reconciliation was the finance department concerned with then? That the $50,000 was received and recorded as a receipt?
And how, if it was dispersed out of the account, how that was accounted for as well.
Does that mean to say that the finance team had a role to play in reconciling, let's say, customer A deposits funds, games, ends up with, at the end of the gaming period, a positive balance? The funds are dispersed at the end of that period. The finance team would be involved in identifying the reconciliation process.
No, I think that would have been done within the Psycho system.
Right. And so is it the case that the finance team had nothing to do with the Psycho system? They weren't reviewing it?
I'm not completely sure of what processes they adopted, but their interest was not in allocating those funds to the customer accounts or accounting for how the customers play activity eventually.
So as part of the reconciliation and what the finance department was doing, did they have occasion to consider the individual transactions in the Riverbank Investments account, to your knowledge?
I don't know.
Did you understand the finance team members in Perth to have received AML CTF training?
I don't know specifically, but it would have been part of the induction and part of the ongoing training.
And do you know if they received a specific training, or was it the online version that we saw earlier?
I don't know.
All right, can I ask you then, you may have already in part answered this, but specifically then, what you mean by overseen by the VIP international business?
Yes, so they had the relationship with the customer. So from their perspective, they wanted to ensure that if there were funds received from one of their customers, that those were properly made available when the patron came to visit.
And do you understand then that members of the VIP international team had access to the online banking platform for Riverbank Investments?
I don't know if they did.
Do you understand the process, if any, by which they were able to ensure that their overseas patron received the correct allocation in Psycho?
Not the specific process that they would have used to do that.
Do you understand that they had access to the Psycho system itself and the reporting function?
They certainly had access to Psycho.
And I've forgotten, Mr. Barton, whether you answered this question if I asked it. Did you understand them to have access to the Riverbank Investments accounts statements?
I'm sorry, I missed the start of that question.
Did members of the finance team, the VIP international business team, have access to Riverbank Investments bank statements?
I don't know specifically, but I would expect so.
So I missed that last part of the answer. Did you say you would expect so?
I would expect so.
How large was the VIP international team in the period between 2013 and when the junket periods stopped into 2020?
I wouldn't have an accurate estimate of that. It was a sizable team, but I couldn't give you a number.
Were they all located in Melbourne?
The commercial and marketing teams were in Melbourne. There were some VIP employees in Perth on the hosting side.
Those employed on the hosting side, they were not the people interested in whether the funds got allocated correctly, were they?
No, that was principally the commercial team.
And do I understand those people to have been predominantly or entirely in Melbourne, at least from 2017?
Predominantly, or if not entirely.
All right. The last aspect of this paragraph refers to AML controls implemented by the AML team. Did you have an understanding of what the AML controls were?
Some understanding, yes.
Now, I'm now talking about something more specific than merely the AML CTF program I showed you earlier. Did you have an understanding of the operating procedures of the AML team?
Some understanding of the procedures, yes.
And when did you gain that understanding?
In 2014, I did attend some meetings where there were discussions or presentations from the AML team about the way they managed AML processes across the bank accounts.
All right. I want to come back to those meetings in a moment, Mr. Barton. But before I do, I just want to finish off on this section of your statement. There's, in paragraph 159, sorry, just before we go back to that, in 154 you've mentioned the three areas I've described. You've got finance team, VIP International and AML team. A little earlier in response to one of my earlier questions, you indicated that the Riverbank Investments account was also used not only by international patrons but local patrons as well. What did you have any understanding of who, if anyone, at Crown Perth was exercising the same function as VIP International with respect to domestic patrons? That is to say, ensuring that the relevant patrons' funds were allocated to the correct patron in psycho.
And most of that activity was done at the cage.
All right. So is it your understanding that the point of contact for domestic patrons, to the extent that Riverbank Investments was operated, was the cage?
Yes, and also they may have done some of that work for international patrons as well.
Okay, then that might also answer the next question I've got, which is if I could draw your attention to paragraph 159, which is dealing with transfer of funds between accounts. Now, you might recall a little earlier, I asked you some questions about the collection or sweeping of Crown Perth accounts and moving funds into a central account for the Crown Group. Do you know or understand if there was a similar process undertaken within Crown Perth itself? That's to say, at some point during the day or the week or the month, funds would be swept from the Riverbank Investments account and taken into an operating account of Crown Perth.
I wouldn't have any knowledge of that process.
All right. So in 159, you say you have no specific knowledge of the person responsible for the transfer of funds for use by patrons. And you say that typically occurs as part of cage operations. What are you describing there? Is that let's take the example of Riverbank Investments. an amount is deposited into the account, it becomes available for use in gaming at what point?
When the patron typically presents themselves at the cage with the ability to demonstrate evidence that they were the party that deposited the funds, and at that point, the patron would have access to those funds.
All right. So at that point, the funds can remain in Riverbank's investments account, or be somewhere else within the Crown Perth group. But the point is that the patron presents, and there's an allocation process undertaken at the cage. Is that the nub of it?
Well, again, this is an understanding that would be funds that they would record in Psycho as available to the patron, and then the patron would be able to obtain an instrument against those funds in their Psycho balance, be it a chips or a chip purchase voucher or some instrument.
All right. Now, do you have any knowledge or understanding of the process, if any, by which the funds were ultimately moved from Riverbank Investments to another Crown Group account?
Not the detail of that process.
Well, without knowing the detail, what do you know of the process?
Well, I know that within the Treasury team, if there was surplus funds across Crown's bank accounts, they would typically be swept into one consolidated account.
Okay, so if I could take you back then to the earlier issues we were dealing with in terms of the sweeping, did the Treasury function apply equally to the Riverbank Investments account as it did to Burswood Nominees accounts?
Yes.
I see. So would it be the case then that, I think, again, I'm paraphrasing what you said earlier, I think it was, you described it as a more ad hoc arrangement. So when someone in Treasury noticed there was a large balance, there may be a sweeping of the funds. Is it your understanding that's how it operated with Riverbank Investments as well?
That's my understanding, yes.
And who within the Treasury function in the period 2013 to when you left had the primary responsibility for that function?
There may have been others in the Treasury function early on in that period, but at the end, it was the Treasury function was essentially just Mr. Costin. All
right. Now, do I understand that the Treasury would have had or did have access to the online banking system for Riverbank Investments, Burswood Nominees, and any subsidiaries in the Crown Group?
They would have had access to whatever online banking information was available.
And they, presumably as part of their function in considering the sweeping of accounts, would have been able to view the individual transactions either online or by way of a paper record?
I don't know specifically that.
It was not something you undertook yourself, Mr. Barton, I take it?
No, I didn't.
Again, I think we may have already touched on this a bit, Mr. Barton, but I want to take you to it in any event. Paragraph 161 of your statement makes reference to the division of responsibilities in respect of the account. Now, I think we've dealt with the first sentence, which is the process of reconciliation by finance. The second sentence I think we've also dealt with, which is the process of allocating money to the individual patron. I want to ask you to elaborate on the third sentence, which is the responsibility for ensuring compliance with the AML CTF program and procedures. What is your understanding of the nature of the responsibility that the AML team had for ensuring compliance with the AML CTF programs and procedures?
As it relates to the bank accounts of Riverbank, what I'm referring there to is the transaction monitoring program.
Okay, and is this, are you referring here to the process by which a printout or a report would be prepared periodically and reviewed manually by members of the AML team and considered for AUSTRAC reporting requirements?
Yes, in relation to some aspects of reporting. And I'm not completely familiar with the detail, but international funds transfer instructions would be one aspect of the reporting. Threshold transactions would be another. But I think specifically the reporting out of Psycho was used for any suspicious matters reporting.
Yes, so for example, if they noticed that a cash deposit took place at the cage exceeding $10,000, they would ensure that a threshold transaction report had been made to AUSTRAC.
I understand that is the case, but I'm not sure that they would have been reviewing that, but I expect they would have been.
And when you talk about suspicious matter reports, is your reference there to reviewing, having a look at the entries in the Psycho, on the Psycho system, and considering patterns and whether there's some reason that some activity by a particular patron may be suspicious, and whether a suspicious matter report should be made to AUSTRAC?
Yes, that's correct.
Did you understand whether, or did you know whether it was any part of their function to consider source information? So, for example, to review the Riverbank Investments bank statements themselves?
The AML team?
Yes.
My understanding is at the time, the Riverbank accounts were being reviewed, that wasn't part of what they did.
And when you say at the time, you're referring to this period 2013 until something changed?
Quite recently, I understand that now part of the AML program, as of last year, is that they also get information directly from the bank statements.
Right. Now, that was one of the last point, which is the change where the AML team review bank statements, the source information. That happened during the period you were CEO of Crown Resorts, didn't it?
That's right.
And it happened after the Bergen inquiry commenced.
It happened through the course of after it commenced, yes.
So prior to that, the AML team, to your knowledge and your understanding of the system, was not reviewing Riverbank Investments or any other account of Burswood nominees, any account of Burswood nominees, as a source of information from an AML CTF perspective.
My understanding is their information came from the Psycho system.
Now, insofar as the Psycho system goes, that was also a manual process, wasn't it? Sorry, I should start by saying in the period 2013 until more recently, that was a manual process.
So when you say a manual process?
A person had to take a report and look at it and form a view about whether there was anything suspicious in the transactions.
There was some automation underway, I think, towards the end of 2019, but more significantly in 2020. But before that, it was a manual process of reviewing Psycho printouts to prepare suspicious matter reports.
All right. So when you're referring now to the automated process, is that a reference to the Sentinel system?
Yes, that's right.
And it began during the end of 2019 and throughout 2020?
That's my recollection.
All right. But prior to that, it was an entirely manual operation?
Yes, that's right.
And even when Sentinel began, you continued the manual aspect, didn't you?
Yes, that's right.
So up until, you can break this up into periods. To your knowledge, how many members of the AML CTF team were undertaking the review of transactions in Psycho for Crown Perth?
My understanding is there was one full-time employee on AML from 2013 until 2000 and probably 18, 19.
And after 2018?
The team was growing over time, and I believe by around 2020, I think there was either 2 or 3 people in Perth. And I think it was growing since then as well.
And during the period you were CEO, did you make any changes to those numbers?
We were adding numbers. The total team in 2020 by around September, October was up to, I think, 15 positions. Some of those were being filled. And I think since then it's grown more.
And when we're talking about 15, is this across both Perth and Melbourne, or specifically?
Yes, that's right.
To Perth?
That's Perth and Melbourne.
All right. So were any specifically dedicated to the function in Perth, or was it simply a group function?
There were some dedicated in Perth, and then people in the group function also supported both Perth and Melbourne.
All right. So insofar as Perth is concerned, am I right in understanding that up until 2018, one person?
I may not be completely right with that, but I know at one stage there was one person. I don't know in 2018 if there was one or more.
All right. And then 2018 to 2022, two people? Again, give or take?
I think that's right.
And then in 2020, you undertook increasing the size of the team by quite a significant margin.
Mr. Stokes, at the end of 2019 and into 20 was building out the team, and I think since then it's been built out more.
All right. Can I just ask you to confirm something? So if I take you to 162 to 166 of your statement, and in particular to 162, this is in response to a question about your awareness of the extent to which the operation of the Riverbank accounts were accounted for in the AML CTF program of the Crown Group. And some of the same subject matter we've just been traversing, Mr. Barton. You make reference to previous answers to previous topics and also to your Bergen inquiry statements without any specific reference to which one. Could I take you to some of those statements and ask you if they are what you had in mind? Because I think it might be the most efficient way of dealing with this. So, you quote your third statement, which is CRL.697.001.0033. And on page pinpoint 0042, there's a heading AML/CTF, and then a number of paragraphs that follow from that. And it ends, I think it goes from 54 to 79. Are they at least some of the paragraphs you had in mind when you made reference to your Bergen inquiry statements?
I've only got 54 to 56 on the screen at the moment.
All right, you will need to, and you can take your time, Mr. Barton. In fact, what I might do, Mr. Barton, because I think we're about to run into the lunch break, if I give you the references and you can look at them over the lunch, it might assist.
I think that's an appropriate course, yes.
All right. So, Mr. Barton, the references I wish to draw your attention to are your third statement, paragraphs 54 to 79, your fourth statement, 14 to 21, and that is CRL 0.730.001.1547. And your sixth statement, which is CRL 744.001.0001 at paragraphs 23 to 33. And if there are any others I've missed, then could you let me know when we come back from the lunch and adjournment?
Yes.
Sorry, Mr. Barton, while I've got you, before we break, I've got another question for you. Similarly, with respect to your answers to topic 54B and C, I think they are addressed in paragraphs 11 to 22 of your sixth witness statement in the Bergen inquiry. And while I'm on the subject, again, this should make things more efficient, Mr. Barton. You've dealt with the question of a closure of accounts. You recall this, to do with the closure of the ANZ and CBA account. In your witness statement, in this matter, at paragraphs 168 through to 174, and again, you've referred to your Bergen inquiry statements. In that respect, could you confirm the paragraphs in question are in your third witness statement, paragraphs 22 to 53, in your fourth witness statement, paragraphs 5 to 11 and 13, and in your fifth witness statement, paragraphs 5 to 6 and 8 to 10. And again, if there's anything else you wish to draw my attention to, the Commission's attention to, or if any of that is incorrect, then please let me know after lunch and adjournment.
Yes.
Now, I can't. I thought. Sorry, in my mind we were going to keep going until we got to 10 to 1, but I've now realised it's 1 o'clock. So sorry, my apologies, Commissioners. What time are we breaking?
1 p.m.
1 p.m. All right. Then, if that's right, then Mr. Barton, I'll just see if there's any others I can add to this list. No, I think that's all. Would that be convenient?
I have a short question.
Yes, sorry.
Unless you...
No, I would be prepared, if it's convenient for the Commission to break now, because it'll take Mr. Barton some time to read through that stuff.
All right. Well, Mr. Barton, just before we break, I wonder if you can... You may not be able to, but I wonder if you can help me with this. It's about the Riverbank accounts. And what I'm interested in is the process by which the money goes from the bank, ANZ or CBA, into the Crown Perth accounts. Are you able to tell me the process? Let me go back to see if my understanding is correct.
I'm sorry, Commissioner, the line dropped out there for a moment.
Okay. I'm interested in the process by which the money gets from the bank, ANZ or CBA, into the Crown Perth accounts. That's the topic. That's the broad topic. And I'm wondering if you can help me with that. So a depositor, be it domestic or international, deposits money into the Riverbank account at the bank. So there's a transaction between the depositor and the bank in that sense. Eventually, the money is credited to the patron's account within, as I understand it, the cage structure of Crown Perth. So my question is, what is the process by which, what is the trigger by which the money leaves the bank and arrives at Crown Perth?
Well, and I may be misunderstanding the question. The funds, once they're received into the bank account, would be considered to be Crown Perth's funds. The patron would have access to those funds, and so there would be a credit, if you like, to their customer balance in the psycho system, and that's just an internal accounting entry. So the patron would have access to a balance that's created in an internal ledger account, if you like, within the psycho system for that patron. So they're able to use that to draw down, to gamble and receive chips. But the funds are always, the actual cash funds are always within Crown's control. There may be payouts for winnings or other reductions to the balance, but essentially once they are in that bank account, they're in Crown's hands.
I think perhaps I phrased that badly. The Riverbank account is of course an account under the control of Crown Perth, but the patron has made a deposit. What is the process by which the people within the cage, or whoever it is that's responsible, the finance team, become aware that there must be a removal of funds from the Riverbank account into the patron's, the ledger account, if you like, of the patron? Is that something that happened automatically on a review of the bank statements? I'm asking you if you have knowledge, personal knowledge of this, or whether there was some communication between the patron and the Crown finance team that precipitated the creation of that ledger entry.
So within the psycho system, what would, if you like, create the change in the balance of the patron's, if you like, credit account?
Yep.
Would be when the patron is at the cage with evidence of the funds that were being deposited on their account through the banking system. So they would present themselves at the cage. They would demonstrate that the deposit was on their account. There would typically be some details in the deposit. And once that was matched and verified by the cage, then they would, in a sense, release that balance to the patron to draw down on out of their psycho system balance.
So this then is still part of what has been referred to as a manual operation, rather than some automated system by which the transaction at the bank between the depositor and the bank was automatically entered into psycho. Is that right?
It is a manual system, Commissioner, yes, that somebody needs to intervene to verify that the money that was received in Crown's bank account is properly for the credit of that patron.
Right, thank you. Mr. Barton, we've left you with some homework, so perhaps
Yes, indeed.
for a full hour, and we'll come back at 2 p.m. our time, which is 4 p.m. your time.
Thank you, Commissioner.
So 2 p.m.